Well, welcome back to CVine International News Network. I'm Linda Forsythe.
And I'm Leonard Bacani.
We are going over today the second part. This is part 2 on our discussion of the military tribunals that are going on in Guantanamo Bay, Cuba, at GITMO. And we had our session yesterday, which went over day 1, which the tribunals are starting, or were starting on January 28th and to be going on to February 2nd, I believe it was. And the tribunals from GITMO are being live streamed via CCTV to various different military bases around the U.S. And Leonard and I are in Maryland and Washington, D.C., where we were on Fort Meade, their military base, to be able to watch the proceedings from their special room that they have for the press. What is interesting, I'm going to briefly go over, is mainstream media was not invited to cover these proceedings. You won't be hearing about this anywhere on mainstream media. Isn't that interesting? But they did put out a public release. The Department of Defense, the DoD, put out a press release requesting that alternative media apply and go through the process in order to be able to be approved to have press passes to be able to cover these proceedings. And this is why Leonard and I are here. Now, you should be aware that we are reiterating that these proceedings are exactly what we saw, are exactly what everyone else saw in GITMO. There is a 40-second delay from what is said in GITMO to what the public and or the press or the witnesses hear. This includes GITMO. People in GITMO are all behind a special wall, soundproof room with 40-second delay before you hear anything. Same thing with us here in Washington, D.C., in Maryland at Fort Meade. So what we moved forward, we heard what everyone else did, but also we have been advised to hold off until the transcriptions come through, because in case something comes through, that 40-second delay, that shouldn't be, the transcriptions will be redacting top secret information. So this is why we can't come to you live every single day. We have to follow the rules. Now, at first, we were really excited that the alternative media were going to be the ones that were covering these. But as you'll be able to tell in moving forward as we report this to you, part of the mainstream media may not have wanted to cover these proceedings because there has been an unusually high amount of discussion and effort to make these proceedings closed. And you will be hearing that there is a very high bar that must be met in order for military tribunal sessions to be closed. There has to be some significant proof of how there will be a release of top secret security information. So it's just interesting. You'll see what I mean as we move forward. If you have not listened to part 1, which was day 1 on January 28th of the military proceedings, please go back and take the time and listen to our recording and also read the report, with the understanding also that we have made these transcriptions available to you, the public. This is for public review after the DoD has approved it. So take the time. I'm serious. Even though these are pre-trial hearings, you're going to be seeing some things here that you're going to want to know about. Okay, so I think they may be counting on there isn't going to be that much public interest, especially since alternative media is covering it. You're going to want to know about this stuff. So we have a PDF of the transcript located in the report on part 1. And we're going to be doing the same thing here in part 2. very briefly, yesterday, I'm going to let Leonard go over what happened yesterday that you were going to need to pay attention to.
Basically, one of the defense attorneys for one of the accused raised it was an objection, or actually it was gave the judge notice of a possible conflict in which, and one of their team members, which I found out was a sergeant in the Army, and he was a paralegal for the defense. Well, basically, this defense attorney complained to the judge about this rough surveillance that was going on and involving 4 agencies. The agencies involved CIA, FBI, military intelligence, as well as the Army intelligence. They participated in this so-called rough surveillance of one of these team members, in which the team member lives near Fort Ord and catches this guy out in front of his out in front of his house, taking cell phone pictures. Well, he gets in his car, and the guy takes off. The guy doing the surveillance or taking pictures takes off, and the sergeant follows him. Well, the guy taking the pictures bails out of the car and runs between the houses, and he's ghost. He's gone. And so the sergeant gets in his car, and he realizes that he's being followed by another subject in another car. So now at this point, he realizes that he's being surveilled and followed by a team of individuals, more than one. So the sergeant makes a U-turn in hopes of maybe losing his tail, this surveillance. But eventually, the sergeant makes it to his work at Fort Meade. And upon arrival, he's met by 5 law enforcement officers, both from the military police as well as civilian police. And then he's confronted by 2 individuals who identify themselves as special agents of the Federal Bureau of Investigation. And they subject him to about 2.5 hours of interrogation. And during this time, they're telling him, "Hey, we know about you. We know about what's going on with this defendant or accused, having a lot of knowledge, stuff that you have to be intimately involved." So, in other words, they may have had a mole or a plant, or somehow knew all the information regarding the accused defense. Well, he's told, come back the next day, and the sergeant does come back the next day, and he's subjected to not 1, but 2 polygraphs. And so this is what's going on, that the defense attorneys found out about it, and they're raising the issue, or basically complaining to the judge about it, this rough surveillance.
Well, that's very well said, Leonard. And there was one thing that I don't think came across clearly. It's Army and military counterintelligence that was involved in this. But that also being said, it wasn't just this one guy that this has been happening to. Apparently, for the last 10 years, there has been continuing, ongoing saga of this type of thing. And it isn't just, typical surveillance, in which, of course, you would want, defense team that is going to be representing the terrorists to make certain that they're above board and there's no collaboration with the enemy or anything underhanded going on. So, that I agree with. There is no question with that. But this is over the top. And it's also, threatening, it's intimidating not only them, but the family members. They were saying, what their family and where they are and so on. That quite a few people on the defense teams over the years have quit, moved on to other places because it just was over the top. So the defense brought this up to Judge Perella, that he wanted this situation to be resolved. So that was what our discussion was yesterday.
You know what? Linda and I don't see eye to eye all the time. Coming from a law enforcement background, hey, I don't find any problem with the investigative techniques that the investigators used. Yeah, it was they pressed on the defense team, but they wanted to know, they wanted to make sure that they were collaborating with the enemy and whatnot. So Linda considers it over the top. I consider it a good investigative work.
Well, there's a reason I consider it a little bit over the top. It's because of what else comes up in these proceedings. And if all you had heard was just the initial beginning of it, I concur. I concur with exactly what Leonard is saying. But other things are coming to light. And we will be going over that. And you make your own decision. You guys are going to be reading these transcripts, right? So, nothing's being held from you. This is not just our opinion and our arguing back and forth and debating a situation. You read it, you decide, you come to some of your own conclusions, and go to our Facebook group page, the Seavine International News Facebook group page, where we have citizens, we the people that are there discussing, debating these issues. So with that being said, Leonard, let's go ahead and start with what happened on day 2.
Well, before we do, I'd just like to add that this is just the beginning. This is the very first proceeding that's opened up to the alternative media. And what we're really looking forward to is the stars, the famous politicians who will be tried in military tribunals. So I just wanted to throw that in there.
I think all of us are hoping and waiting for some activity in some of these areas. But yes, this is just the beginning. Okay, let's start with day 2, which is Tuesday on the 29th.
Well, on the 29th of January, the court was called to order by a military court judge, Colonel Perella, at 14:06 Guantanamo time. 14:06 is 2:06 p.m. And it was apparent that all the accused or the defendants were not present in the courtroom. All parties were there in the previous session, except with the exception of all the accused. Mm-hmm. So they had an unnamed police, or not police, but Navy captain was called to the witness stand for the prosecution and gave us sworn testimony and testified that all 5 accused defendants or accused signed a 3-page document basically waiving their rights to be in attendance at the proceedings. But Mr. Nevin, who is the lead defense counsel for the accused, he says, he's talking to the judge, he says, "I renew the objection that I raised with you yesterday regarding our inability to resolve our conflict. And so we won't be, as we said this morning in the closed session, we will not be participating in the proceedings pending resolution of those issues." So what apparently happened was we were wondering why there was nothing going on in the morning. So we find out that they did have a session, but it was closed. It was closed to the media. So we don't know exactly what went on, but apparently this defense attorney is making objections from some of the testimony from that hearing.
To make clear, he's renewing an objection that he raised yesterday, that he rose again the next day on the 29th in the closed proceedings. So he is bringing it up here a third time at this point about this rough surveillance. That is the point that he is talking about.
Right. Mr. Nevins repeats his objection and he tells the judge, "I felt that I should renew this request we made previously that the proceedings be recessed pending resolution of this proceedings." So he not only says a second time, but Mr. Nevins repeats it a third time, and he says, so I renew that, I give you that information, and I renew that request. So that's significant. So what's going on here is it's apparent that the defense attorney is aware of the cameras, is aware that it's going to get to the public. So they want to basically let everybody know, put it on record that they're objecting, and they're playing to the cameras.
Well, yeah, playing to the cameras is one way of looking at it, and that may be the case. But, to bring this up about this rough surveillance that was discussed the day before, that apparently has been going on for 10 years, I want to reiterate the first thing that you will see in the transcript when you read it. I'm going to reiterate it again. This is the first time he said it that afternoon. I renew the objection that I raised with you yesterday regarding our inability to resolve our conflict. And so we won't be, as we said this morning in the closed sessions, we will not be participating in these proceedings pending resolution of those issues. So he's taking a hard line there. Whether or not, that can happen, who knows? But he's making clear, I brought this up yesterday. I brought it up in the closed proceeding. I am bringing it up again. We're not moving forward here. We are not going to be participating in these proceedings pending resolution of those issues. And that's when he repeats it another time and another time. So we're talking about 5 times, 1 time in closed proceedings, 1 time the day before, and 3 times on the second day. So yes, he wanted it public record. He was making it pretty clear.
Well, the judge tells Mr. Nevins, I understand, Mr. Nevins, the commission obviously stands by its earlier ruling from yesterday, but I will consider that your objection or your request is ongoing, at least from the commission's perspective. So another lead defense counsel chimes in and he says, the military commission will please note my objection to the anonymous testimony. So he's referring to the closed door session from earlier that morning about an anonymous testimony. The judge says, I will. And Mr. Connell says, and second, we did this in the closed session, but I want to renew my objection to proceeding under Rule 805 while Captain Andrew is not present, being sick in quarters. And Mr. Perella, or the judge, says, thank you, Mr. Connell. Your objection with respect to anonymous testimony is overruled. So he shuts him down. With respect to Captain Andrew, the commission stands by its earlier ruling that it made in the closed session with respect to my finding that under the circumstances, a continuance is not warranted. I would ask you to continue to keep the commission apprised of Captain Andrew's status. So if you listened to our broadcast yesterday, what happened was Captain Andrew, one of the attorneys for the defendants or accused, was sick. So there was another defense counsel that took his place. His name is Mr. Connell. The judge didn't find any reason to suspend the hearing because the lead attorney was not there. He said as long as the accused is represented by at least one counsel, that's fine with him. So this other counsel, Mr. McConnell, is objecting to that.
Okay. It's, I don't know if I mentioned it in this taping, so please forgive me if I'm being redundant, but I wanted to make clear that these proceedings are covering 5 accused all at once. Did I mention that in the beginning this time?
Yeah, yeah, and the judge mentions that as far as his ruling. Uh, Earlier, we said that it was apparent that the defendants or the accused, all five of them, were not in the courtroom. Well, Mr. The judge says the commission finds that, and he names off the accused, Mr. Mohammad, Mr. Bin Atash, Mr. Bin Hashish,
Then there should be.
Bin Al Shabi, Mr. Ali, Mr. Hawas, we have knowingly and voluntarily waived their right to be present at today's session. So basically, the accused don't show up, and the judge says we're proceeding anyways. It's their right not to attend. Okay, so another defense attorney, Miss Prodhan, says, Your Honor, just to set the stage, we are here on AE 616, which follows the order of AE 350RR from the Military Commission ordering the testimony of former interpreter for Mr. Bin Alish team to testify tomorrow by secure video conference by closed in its closed session pursuant following AE 350RR. Mr. Al-Balushi put on record his objection to unclassified testimony being taken in a classified session, and the military commission then ruled, asked the parties to brief their positions on this. So it is our position that actually, because the government is moving to close the session, the government bears the burden of proof here, which I'll talk about in a minute, according to this Ms. Pradham. The judge says, I understand, referring to Mr. Evan, the commission obviously stands by its earlier ruling from yesterday, but I will consider your objection on your request is ongoing, at least from the commission's perspective.
So to discuss this, the judge is basically saying that the issue that the defense has requested 5 separate times about the rough surveillance that was going on, for the most part, it appears to be a non-issue. We aren't really addressing it. Not moving forward, and it stayed the same. And they are pushing for the proceedings to be done in a closed session, even though the information in the closed session is not considered classified. So this is why Mr. Al-Balushi was putting on record his objection to unclassified testimony being taken in a classified session. So it's interesting that the accused is really pushing for things to be in an open session. They want the public.
Exactly. That's what they want then. Their whole objective is to get this out in the open. Obviously, the government wants to maintain its secret, wants to maintain its integrity, and wants to maintain the integrity of the investigation, not only this investigation, but future investigations. And the defense attorneys want to make a show of it. They want to let everybody know what's going on and reveal the secrets.
Well, everyone who knows me pretty much knows I'm a pretty strong Trump supporter, and I'm a patriot. And when we look at some of the things that were going on in trials, how many times the left, the liberal left, the Democrats wanted things in a closed session. And Trump's like, no, I want it out in the open, including, press and etc. It wants transparency. And the only reason I am bringing this up is because of something that's going to be coming up here that I want you to pay close attention to. Now, one of the things the defense states, and you will hear, that to have closed proceedings It has to be met because a military tribunal is meant to be open to the public. So the public can closely hear, scrutinize, and listen.
Now, that's the executive order that Trump had signed. He wanted it open.
He wanted it open. Okay, that's something else in addition. That is something to take note. So she states, as you will hear coming up, to have a session closed, it has to meet a very high bar, meaning you have to show that there is definitive secrets and or defense issues that could possibly put the country or people or situations in danger in order to be able to be held in a closed session. And you will be hearing that those objections are not met. So again, things are just kind of interesting. Just keep your mind open and be reading again these things yourself. So do you mind if I
No, go for it.
move forward? Okay, these issues right here, I'm going to be reading, instead of putting so much of my own input into it, directly from the proverbial horse's mouth. I'm going to be reading to you exactly what these people are saying, and I request that you listen very closely and or follow along in your transcripts that you have. Now, it starts from where Leonard left off. We will now turn to AE 616, and we'll start by Mr. McConnell. I believe that your team has the proponent initially of the issue in this one, so I'll afford you the first opportunity to be heard should you choose to. And Ms. Pradhan said, "Good afternoon, Your Honor." Your Honor says, "Good afternoon." Ms. Pradhan states, "Your Honor, just to set the stage, we are here on AE 616, which was, follows the order in AE 350RRR from the Military Commission ordering the testimony of a former interpreter for Mr. Banal Shibaz's team to testify tomorrow by secure video conference in a closed session. Pursuant, following AE 350RRR, Mr. Al Belushi put on record his objection to unclassified testimony being taken in a classified session, and the Military Commission then ruled, asked the parties to brief their positions on this. So it is our position that actually, because the government is moving to close the session, the government bears the burden of proof here, which I'll talk about in a minute, says Ms. Pradhan. As I mentioned, the interpreter is due to testify tomorrow, which would have been Wednesday, January 30th. And under AE 350RRR, there are two areas of inquiry for the testimony of this interpreter. The first is how he sought employment with the Military Commission's defense organization, and the second is whether anything or anyone prevented him from disclosing to MCDO his previous employment with the CIA. Now, the bar to close a hearing, and this is quote, is very, very high under both the First and the Sixth Amendments, and under the regulation for trial by Military Commission Section 19-1 and by Military Commission Rule 806A that says military commissions shall be publicly held. The language of the case law bears this out. As we discuss in our brief, the cases talk about closing hearings sparingly, with an emphasis always on holding a public trial. And any party seeking to close the hearing, the government in this case, bears that burden. If we look at the press enterprise criteria, she goes on, regarding the right of public access, none of those criteria here, we believe, have been fulfilled. We have them in turn. The first is an overriding interest that is likely to be prejudiced. Now, protecting classified information is the interest that has been, of course, advanced by the government and is agreed by us. We do have an obligation and interest in protecting classified information. So she's all about that. And we have already taken significant steps to protect that information through the use of pseudonyms and other limitations on the questions that can be asked of this interpreter and the subject matter that we can cover in a potential open session. We have taken the position to the Military Commission that we would support further restrictions on broadcasting the interpreter's likeness to the court and any other restrictions on voice or images that would be necessary to protect this individual's identity. In other words, the prejudice has been mitigated or can be mitigated, and I would posit eliminated to the extent possible by our adherence to the guidance given to us by the government regarding this classified information. In a case like this, it is always going to be a question of how do we balance the rights of the defendants and the public to the default of a public trial with the protection of national security. And this is why we make every effort to bifurcate proceedings when we can, so that the likelihood of that prejudice, that damage, is minimized. But in considering this issue, we equally can't minimize or prejudice the importance of a public trial here, where there is a real question existing in the underlying facts of whether the interpreter's presence on a defense team constitutes an illegal government intrusion into a capital defense case. The second criteria, she goes on, criterion under press enterprise is that the closure must be no broader than necessary to protect the interest. The employment of the interpreter with the Military Commission's defense organization is not classified. The former employment of the interpreter with the CIA is not classified. The fact that the interpreter had a non-disclosure agreement with the CIA is not classified. And in fact, we discussed the details of the interpreter's history with the MCDO and his false statements to defense personnel in open session in November, where we were arguing to call him for testimony. We did so without endangering classified information, as is apparent from the public transcript that's available on mc.mil. So the mere presence of classified information around an issue cannot in itself, thank you, justify closure. Otherwise, this entire proceeding would be closed. And it is the burden of and I think this is redacted, it is the burden of the government to prove that on this issue, as opposed to the many other issues involving torture in the CIA, that we have, and then something else redacted, on which we had open hearings, that this issue merits entirely closed testimony, and they can't fulfill this burden. Again, the personally identifying information of the interpreter and the details of the activities or experience during his employment while with the CIA are classified, and we've dealt with both. We currently have a pseudonym that we've used successfully in open court regarding the interpreter for several years now. We're rounding on 4 years now since the initial incident in February of 2015. So it's up to the government to let us know if they would like to modify that pseudonym, and we will comply with any modifications that need to happen. Almost done here, hold on. The Military Commission has also ruled, of course, that we will not be discussing the details of the previous employment with the CIA, so most, if not all, of the testimony is going to be unclassified matters as per 350 RRR. We will be discussing whether anything or anyone prevented him from disclosing his CIA employment to the defense. Our inquiry into his limitations on that disclosure have to do with whether anyone from his old employment spoke to him ahead of time, whether anyone from the government agencies exerted pressure on him, whether he acted sua sponte, in withholding this very important information? And if so, why did he choose to pursue that route? Now, Colonel Perella, Judge Perella, Ms. Pradhan, when you argued back in November, I believe in response to the Commission's question, you indicated that the relief sought was either a deposition or a testimony. Ms. Pradhan states, yes, sir. Judge Perella, and I understand your argument about the balance, but say I had granted other remedy, a deposition, how would it have factored into that balance, and how would the public have potential access to that? Ms. Pradhan states, well, the facts surrounding that, it would obviously be different physical setup, and we would be conducting that. We would have argued that the deposition, even though it would be necessarily not conducted in front of the public, that parts of the deposition be made public after the fact, either through a declaration or through evidence submitted to the Military Commission publicly in a filing. That's important. So we would not have taken the position that the contents of that deposition be classified or kept classified. We would have fought to make the parts of, at least parts of those depositions, of that deposition, public. Judge Perella, can't I simply order, if we were to do this in a closed session, order that the redacted transcript of the proceeding be made available to the public? Ms. Pradhan, yes, Your Honor, but that a redacted transcript after the fact does not allow the public to access in real time. And there is a discussion of this in the case law about the ability of the public access. Judge Perella states, but neither would have a deposition been accessed in real time. Ms. Pradhan states, no, Your Honor, but given that we do have the potential of live testimony, is live testimony in a public setting has qualities that a deposition conducted in a closed forum does not have. Judge Perella states, but that wasn't really the nature of the motion that got us here in the first place. I mean, the nature of the motion was essentially discovery, which is a request hence the request for a deposition to get information. So presumably, depending on what comes of this testimony, the defense would make an appropriate motion if they chose or find it necessary. So it seems somewhat disingenuous to now change that to where we need this instantaneous access made available to the public. Ms. Pradhan states, no, Your Honor, and that's for two reasons. The first is that when we initially asked for a deposition or for a testimony, we did that with the understanding or with at least the request to the commission that testimony also cover the details of the interpreter's previous employment with the CIA, which we understood. And we understood those details to be classified. And that was the reason that there was a discussion whether we should have a deposition or whether we should have testimony. And the purpose or potential purpose of holding, either one of those in a classified, holding testimony in a classified setting, or having a deposition, that would have classified parts to it. The default, however, of public testimony and the default of the right to a public trial is a public trial. The default is never closure of proceedings and then releasing information to the public after the fact. The default in the Sixth Amendment and the First Amendment right to a public trial is always to keep the proceedings open and to be very, very narrowly tailor the closure of proceedings. And that's what we're asking the Military Commission to do here, that the closure of the proceedings, and we recognize that there may be information that we ask or questions that we ask the interpreter that may come up against classified information, or that the interpreter may feel involves classified information. And we have expressed to the Military Commission our agreement that, of course, there should be bifurcated proceedings. But the idea, that entirety of the proceedings should be closed solely because there are lines of questioning that in in and of themselves are unclassified, but that may, second or third degree out implicate classified information is not sufficient to justify closure under the press enterprise standard. So again, we've done these kinds of questionings before, where we know that there is a strict line of classifications, and the government has given us that guidance, and we appreciate that in this case. But we know what is classified and unclassified about the interpreter's employment. We have those boundaries, and we protect that line, and we save its crossings for closed session. But the line of questioning that I've just outlined to you strikes at the heart of what the public has a clear interest in knowing, which is whether the government is at all involved actively undermining the capital defense in a 9/11 trial. The third criteria under press enterprise is that the trial court has to consider reasonable alternatives. Now, there are several. We can hold open testimony with the interpreter's appearance obscured, either partially or completely, and we know that the government is able to provide disguises if necessary. The military commission can certainly decide that certain questions should be limited to closed session, and that would satisfy, I think, the very narrow bit of classification that pertains to the areas of questioning that have been allowed by the military commission in 350 RRR. And I said in this closed session, and I will submit to you now that we have offered to submit at least our question on behalf of Mr. Al Belushi's ex parte to Your Honor, to the military commission, so that you can make that assessment. The topic of alternatives, though, brings me to the confrontation clause discussion, and it is our position that if the military commission chooses to entirely close the testimony of the interpreter, the defendants would have the right to attend that closed session. In AF 13.6E, Judge Pohl, that's P-O-H-L, ruled in his findings, Section B, that the accused do not enjoy a right to be present at closed pretrial hearings during which classified material will be discussed, for which the accused is not the source of the classified information. Now, in many ways, this is exactly that scenario. But for the defendants, we would not have that information we have today regarding the interpreter. Now, the case law supports the proposition that the defendants must be allowed to attend the interpreter's testimony. The Second Circuit has stated that the presence of the defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence. And we know the defendants have a right to be present at any critical stage of the proceedings. Now, it is a highly fact-specific inquiry, but it turns out on the ability of the defendant to contribute to the conduct of the proceeding. The military commission would need factual development of these issues every time the government seeks to exclude the defendants from a session, and certainly in this particular instance, where we have the relatively rare at this point instance of incidents of live testimony from a former member of a defense team. And here, the interpreter again is being called to discuss how he ended up in a situation that severely compromised and violated the defendant's privilege at a minimum and may have constituted government intrusion into their capital defense. Starts to cite laws to support this position. Okay, phew, I know that was a long one, but you needed to hear every bit of it. Again, you aren't hearing all the different parts of this unless you take the time to read it. But what Ms. Pradham here is saying is significant, very significant. In fact, I highly recommend those of you who are following along in these transcripts to read it again, exactly what is being said. They want the public, minus secure information, to be able to see these hearings. Usually, it would be the other way around where they want it enclosed. I don't think there's any grandstanding going on here. I do personally question why it is so important, and this is my personal opinion, why it is so important for the government to have these proceedings be closed. Because what information might the terrorists put out there about conversations they may have had, with whom, and could possibly, and I have no idea, could possibly be some of those conversations be with individuals that may be rather uncomfortable to certain people in this country to be made known. So, with that being said, I think you would agree, if that is the potential possibility, we would want to know exactly who and what things were discussed with over this very horrific, horrible 2001 9/11 event. So, Leonard, I need a drink of water.
Well, there's more arguments that go on. However, let me just kind of conclude this by saying that at the end, the judge says, "Okay, you understand. I think the commission's position hasn't changed, and the views this as a waiver of your." And then he gets cut off. He gets cut off by defense attorney Mr. Montrose. It is not a waiver. Mr. Benatash does not waive his right to representation. We are proceeding. The judge says, okay, at this point, the commission is going to take this matter under advisement, issue a ruling as soon as practicable, and what I intend to do is recess the commission until tomorrow morning. So here, it's obvious that the judge is planning to return the next morning. Then, of course, we know what happens afterwards. That a medical emergency involving the judge's detached retina occurs, and he has to get flown out of GITMO. But so it's here. It's evident that the judge is planning to be there.
I'm going to interrupt you there. Okay. To reiterate what the judge stated via the transcript. Okay, at this point, the commission is going to take this matter under advisement. Issue a ruling as soon as practical. What I intend to do is recess the commission until tomorrow morning. It could also be looked at as a stalling tactic, but I realize this is what judges do all the time, but I'm the skeptic here. So even though the judge planned to return, there was still a whole lot there that was just political, pushing things off to the side. We'll deal with it at another time. Now, there are some other things here.
Well, a lot of things, what judges do a lot of times is they do research, and they want to make sure they're in good standing as far as complying with the laws, maybe even talking to another judge or something like that, where he's going to do some research. But a lead defense attorney, Mr. Ruiz, says, "Yes, Judge, your ruling in terms of whether there will be an open session or a portion of this open session tomorrow will impact Mr. Al-Hawaski decision whether to come to court tomorrow or not. So what I'm asking is if the commission can urge for us to have an opportunity or a way to communicate that to Mr. Al-Hawaski, that would be helpful." The judge says, what I can propose, and maybe in light of the weather event, is why don't we go ahead and postpone the testimony until Thursday right now? And then that way we can. That gives the commission ample time to issue its ruling. You, Mr. Ruiz, and your counterparts discuss the matter with your clients, and we can take up the unclassified portions of the remaining motion series tomorrow morning. And so there's a few other arguments that are made, but basically the judge recessed the session at 14:38, which is 2:08 Guantanamo time.
Well, there's a couple things here, I'm sorry, I've noticed that I am going to bring to your attention. Weather event. this witness that has to be brought to a fort somewhere within the United States. It does not state where, what fort, what military base they are talking about. But there was deep concern, oh my gosh, deep concern whether this witness was going to be able to make it to this military base to be able to be in this proceeding the next day. Well, what was going on during that time? Conspiracy theory me. Okay, we had an event going on, what was it? 50 degrees below zero in quite a few states. It was a very unusual event, not completely unprecedented. Timing was, as far as I'm concerned, rather interesting. And they were concerned that this witness was going to be there. So they're asking here not only for a continuance, this is the prosecution, I believe, that was asking for the continuance, but because they are concerned that this witness was going to be there in time for this event. So rather interesting that was going on. And then, yes, of course, the judge closes the proceedings. But I wanted to bring that to everybody's attention on what this weather event was and where the actual military base was that this witness had to come to. In the prosecution, it was like that testimony would be rather important. But then again, it was right after this, the judge had the medical emergency to such a degree that he had to be airlifted off of Guantanamo Bay to go stateside to a hospital. They did find out, at least what they're stating was it was a detached retina. Now, another thing I found of interest, I guess, is the Miami Herald, who was reporting this event, touched very lightly on, the judge's medical emergency and what they found out, because information could not be put out there about what the medical emergency was because of the HIPAA Act. So they weren't able to release that, but whether it was some savvy reporter or whatever the case was, got information from the judge's wife saying it was a detached retina. And then, and this is the part I found interesting, if you read the article in the Miami Herald, they went into this long, drawn-out issue about the judge's insurance, about how the judge's insurance wouldn't cover the airlift off of Guantanamo Bay, and which is why he was delayed so much in being airlifted off, in Cuba. And then it went into all the stuff about his insurance not covering other things and how there were going to be these lawsuits. And I thought, what? Why are we discussing this judge's medical insurance and making an issue about it and also publishing it in the Miami Herald when we're talking about, because of this, the military tribunal that was scheduled and was still to be on for next how many days, and some very important issues here were to be decided, were suddenly, ba-boom, they were canceled for the rest of the session. And they will not be coming back again until mid-March. So this is just things to look at, to think about. I think personally, in some ways, it's a good thing that there is this time period, because we, the people, are going to be doing some of our own little footwork here, right? We're going to be checking into this stuff. This is, what about the judge and how he needs to rule about keeping the sessions open or closed? We, the people, do have a voice. We, the people, do have the power. Not if we stay quiet, not if we stay silent, but if we speak up and we start finding out that there are some of our rights that are being abused. Now, if you remember during Judge Kavanaugh's hearing to become SCOTUS, they had, this is information because of Leonard's article that he put out there, that the Democrats' main objection to Judge Kavanaugh being appointed as SCOTUS was not so much Planned Parenthood or, showing favoritism or something to this effect. Their main concern was, is it called traditionalist? Uh, actually a constitutional traditionalist, which has our founding fathers put into place in our Constitution ways to protect our rights from tyranny, from people taking over that are in the government, in control of, are over us, from taking away our rights as individuals, as we the people, as the public. And so that was their biggest, huge concern about having SCOTUS appointed, was because if there's traditionalists, there are all sorts of things within the Constitution of why there are military tribunals, why they need to be publicly open, why they need to be, all this information happening with military tribunals, our rights as we the people. Now, the Democrats certainly did a song and dance, hopping up and down, theatrics, drama, 4 days, in and out of each and every single proceeding. Good Lord. Just to do anything and everything, so Mr. Kavanaugh was not appointed as SCOTUS because he is a constitutionalist. He's a traditionalist. So why, when there's these military tribunals going on, even though they're pre-trials and they're again hoping that these won't be around, they have alternative media covering it, us little nobodies here, to be able to cover it, no mainstream coverage, so that just gives less credibility to these trials, right? Mainstream media isn't interested. And also, why wouldn't they be jumping up and down, going out of their way in various different methods to make these proceedings closed? That is against our Constitution. So I am raising my voice, that when it comes to the Constitution, to maintain being a republic, we the people had better start speaking up. And when we hear about crap like this, we're going to look into it a little bit more. We're not going to be, having any, final decisions and whatever at this point. We're going to really study these some more, but we are also going to discuss this, and we are going to be hyper aware, especially in the next couple of months. Well, I'm done for now. I'm off my soapboxes.
Well, stay tuned. Like I said, Linda mentioned Judge Kavanaugh in that fight, tremendous fight that they had in the Senate regarding his confirmation and why the Democrats did not want him to be confirmed. Well, as you recall, Senator Graham had questioned Judge Kavanaugh, and one of the things that he questioned him about was the fact that there was a body of law called Law of Armed Conflict, which basically says that anyone who collaborates with the enemy at the time of war, and we are at war still. As a matter of fact, since September 14th, when Congress authorized use of force in the war of terrorism, we never rescinded that resolution. So we are still in the active war.
Technically at war.
Right, and basically what Senator Graham had questioned the Judge Kavanaugh about was that people who commit treasonous crimes during time of war can be tried in a military tribunal jurisdiction.
As enemy combatants.
As enemy combatants. That's very important because they're no longer, afforded some rights under criminal law, which is the civilian body of law that prosecutes civilians. They become enemy combatants, and there's special rules and regulations and investigative techniques that are allowed in the military tribunals, but not allowed in criminal courts. So that's very important. How many politicians can you name off the top of your head who have collaborated with the enemy, who have given aid and comfort to the enemy? How many politicians have betrayed the United States by committing sedition? Sedition is basically trying to undermine the president and giving false testimony and by false pretense.
Obstruction.
And obstruction, but sedition is very serious in itself. Treason, of course, is punishable by death. And so you may see some death penalty cases involving these famous politicians in the future.
Which may not ever happen if, we have these closed sessions and it takes forever to get information out to we the people. Time continues to move forward before they can give us an unredacted,
transcripts.
Thank you. Before they can give us that, I think it is critical that these sessions stay open, because I don't know about you, I want to hear what these guys have to say. It isn't just, the horrible things that they did as terrorists and so on. I want to know if there's anyone within our country, within our government, within the citizenry and or even nationally, that has been plotting the downfall of America through various different means. Don't you? I want to know.
Stay tuned. Follow us at cvine.com, and that's c-vine.com. Also follow us on Facebook. The name of our group is Cvine International News Network. So hope to see you there. Hope to engage some good conversation with new people that will be signing up and get the latest as far as these military tribunals here at Cvine.
Silent majority, no more.
That's right.
MAGA.